Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing a case that was recently decided by the Supreme Court, or three cases. It's about the defense of extreme intoxication. If a person becomes so impaired by drugs or even alcohol that they don't know what they're doing, that they're essentially operating as an automaton, is that a defense for crimes that they commit while in that state? That's what the Supreme Court was recently asked to rule on in these three cases, Sullivan, Chan, and Brown. The individuals in those cases, Sullivan, Chan, and Brown, had all separately committed violent crimes while they were in what they argue was an automaton state. But under the existing criminal code, self-induced intoxication is not a defense for those crimes. Here today to talk about the case and what the Supreme Court decided are two lawyers, Conor Bildfell and Sina Shabastari. Thank you both so much for joining me today. Let's start by going over the facts of the three different cases briefly. These are unrelated cases, but because they kind of involve similar principles, they were heard together at the appeal. So Sina, what happened first in the Chan case?
Hi, Christine. Thanks for having me. So Mr. Chan had consumed alcohol with several friends and then voluntarily took some magic mushrooms containing psilocybin. When the first dose didn't work, he went back for a second. And once they started to kick in, he began acting erratically. And at first, he went to his family home, continued his erratic behavior, and ultimately ended up at his father's house, where he fell into delusions and thought that his father was Satan, and ended up stabbing his father and his father's partner. And sadly, his father passed from his injuries.
And he was quite young, wasn't he?
He was.
Yeah, do you remember how old?
I don't specifically remember his age.
Okay, but my recollection is that he was young, but obviously charged as an adult. I understand. Conor, what can you tell us about what happened in the Brown case?
Sure. Mr. Brown attended a house party where he consumed alcohol and magic mushrooms. Now, magic mushrooms contain a compound called psilocybin, which can bring about hallucinations. Mr. Brown basically lost grip on reality, broke into a nearby home, and attacked the occupant with a broken broom handle. And it's worth noting that the evidence was that Mr. Brown was not merely drunk or high. He was in a psychotic state and had no voluntary control over his actions. He was eventually arrested and charged with breaking and entering and with aggravated assault.
So I understand why those two cases were heard together. It's obviously both involving the same hallucinogenic agent, psilocybin. Sina, what about the Sullivan case, which was slightly different?
So Mr. Sullivan had a history of mental illness as well as substance abuse. He voluntarily took an overdose of a prescription drug that he was provided called Wellbutrin, which is something that is as an antidepressant. And he did that in an effort to commit suicide and fell into a drug-induced psychosis. And he became delusional and attacked his mother with a knife and injured her. Unfortunately, his mother did die, but not of the related injuries to the attack. And Mr. Sullivan, when police found him at the scene, was ranting in a delusional fashion, and similarly in also a psychotic episode, which resolved itself a number of days later.
Now, Conor, all three of these cases involved people who claim that they were not in control of their actions, but under the criminal code, a defense of self-induced intoxication is not available. What can you tell us about that?
That's right. So this case is all about the defense of what's called extreme intoxication akin to automatism. And in a nutshell, what the Supreme Court held in this case was that Parliament enacted an unconstitutional law. Section 33.1 of the Criminal Code prohibited accused persons from relying on this defense in cases involving harm to bodily integrity. But the Supreme Court held that the law was unconstitutional because it permitted an accused to be convicted even without proof that the accused committed the guilty acts voluntarily or had the guilty mind necessary for a conviction. So, Christine, one of the fundamental tenets of Canadian criminal law that is reflected in the Charter is that we only punish people if they committed a prohibited act voluntarily and with the necessary guilty mind. The Supreme Court held that when someone's in a state of extreme intoxication that's akin to automatism, that renders them unable to voluntarily control their actions. And so the two conditions are not met.